Hello, my name is Fakhr Abbas and this is my student ID. Today I'm here for giving legal advice on Haneens Rights regarding fabric and sewing machine. In this case, Haneen is expanding her tailoring business and purchased a sewing machine and fabric to start creating custom wedding dresses. Unfortunately, both items delivered are problematic. The fabric is not described as Haneen ordered white silk but received cream silk instead. Moreover, it caused a rash due to incompatibility with her sensitive skin, which further complicates the situation. The sewing machine was also sold to her with third-party rights, meaning to the incumbent, preventing Haneen from using it as intended. These issues triggered the need for consumer protection law to determine her legal rights and remedies. Haneen's main objective now is to secure an outcome that addresses both breaches under relevant legislation, notably the Consumer Right Act 2015. The legal framework is critical in this case because it outlines Haneen's rights under various consumer protection law. The Consumer Right Act 2015 ensures that goods must be fit for purpose, satisfactory in quality, and match their description, which directly applies to both the fabrics and the sewing machine. The Sales of Goods Act 1979 provides that goods must be conform to the seller descriptions, and it's instrumental when addressing to the misdescription of the fabric. The Supply of Goods and Service Act 1982 is pertinent for evaluating the goods and for evaluating the sewing machine fitness for purpose. Lastly, contract law governs breach such as the third party rights attached to the sewing machine, suffering remedies such as refund or replacement. This framework solidifies Haneen's claim. Haneen's case hinges on the incorrect description of the fabric, which is crucial under the Consumer Act 2015. The fabric delivered does not match the description of white silk, which is an explicit breach of the contract regarding description conformity. The issue violates the Sales of Goods Act 1979, which mandates that goods must conform to the description given at the time of purchase. In this context, Haneen can legally reject the fabric and either demand a refund or request a replacement. It is essential to emphasize that the misleading description is not a minor issue. It directly impacts the buyer interest in the transaction. As a result, Haneen has the right to take a legal action to mitigate her losses caused by the breach. The fitness of purpose issue is central to this case, particularly because Haneen specifically asked whether the fabric is suitable for her sensitive skin. The Consumer Right Act 2015 Section 9 mandates that goods must be satisfactory quality and fit for the purpose they are purchased, which is crucial in Haneen's case as she purchased it for bridal gowns. Vakar's assurance that the fabric was suitable for all types of skins exacerbated the breach, as it misled Haneens about the sustainability of the product. The Harbor Vane Tank and Pump Co. Limited 1970 case reinforced the expectations of fitness for purpose. Haneens' trash is not a trivial issue. It demonstrates the seriousness of this breach and entitles her to remedies for both physical and business harm. Under Section 20 of the Consumer Act 2015, Haneen is legally entitled to reject the fabric within 30 days of a full refund due to its failure to meet the satisfactory quality and fitness for purpose. If Haneen prefers, she can demand a replacement of the fabric that aligns with her original order of white silk and that is suitable for her sensitive skin. Given the rash caused, Haneen may also pursue damage to compensate for physical discomfort or loss of business opportunity. These remedies are not merely theoretical, they are legally supported action under consumer law. The ability to reject goods and demand a refund empowers Haneen to resolve this situation swiftly and with minimal loss. The third-party rights issue concerning the sewing machine is a clear violation of the contract, as the machine was sold to Haneen without full title. According to Section 12 of the Sale of Goods Acts 1979, the seller must ensure they have clear title of sell the goods. Selling an encumbered product undermines these fundamental requirements. Hanini is legally entitled to reject the machine since it cannot fulfill its intended purpose. This breach is not an isolated issue. It implicates the entire validity of the sale and Hanin contractual rights. This failure of sister makers to disclose the third-party claims on the machine directly impacts Hanin's ability to use the product, making it an actionable breach under the contract law. Honey remedies for the sewing machine breaches are clearly outlined in consumer protection law. She has the right to get a refund under the Consumer Act 2015 as the sewing machine was not as described and encumbered by third-party rights. Additionally, she can demand a replacement sewing machine that is free from third-party claims. The breach of contract related to the rights to sell entitles Hanins to get further damage if the inability to use the machine misleads to business loss. The 30 days period of time for rejecting the goods as defined under Section 20 gives her a legal window to act. These remedies ensure Haneen's rights are protected and that she can recover from this breach of contract. In this case, Haneen is entitled to multiple remedies for both the fabric and sewing machine issue. Under the Consumer Act 2015, Haneen can reject both goods like for the breaches of contract like sewing machine and fabric. The Sale of Goods Act 1979 strengthened her position by ensuring that goods must be in implied term of quality and ownership. Haneen can request a replacement of both fabric and machine, and she is also entitled to seek a damage for any loss incurred. The comprehensive suite of remedies provides Haneen with a robust legal framework to recover her cost and resolve the breaches. The incorrect delivery of cream silk instead of white silk constitute a serious breach of contract. The Sale of Goods Acts 1979 and Consumer Right Act 2015 both ensures that good must be in a description and fitness for purpose. Haneen's clear expectation was not met and rash caused by the fabric, and the legal remedies available to Haneen, including replacement or refund, are firmly backed by the law. The third-party rights attached to the sewing machine clearly breaches the Sales of Goods Act 1979, which stipulates that the seller must have the right to sell goods. Haneen was misled, and this breach compromises her ability to use that machine as intended. So, under the Section 12 of Sales of Goods Act 1979 directly supports her claim, as it ensures goods are sold free from third-party encumbered. The Consumer Right Act 2015 also protects Haneen rights to goods that are fit for their purpose. Haneen's first course of action is to assert her legal rights by contracting sister makers and formally requesting a refund or replacement for both the fabrics and the sewing machine. All documentation, including purchases, receipts, and communication, must be retained to support her claim. If sister makers fail to respond appropriately, Haneen should escalate the matter to consumer protection agencies to take legal action for breach of contract. Consumer law is on her side, and she must take swift, assertive steps to resolve this situation and mitigate any business losses. Haneen has clear legal rights under the Consumer Right Act 2015 and Sales of Goods Act 1979, including the ability to reject both fabric and sewing machine due to the breach of contract, and also get refund or replacement is the primary remedy, as she can seek damage for any business disruption or any personal harm incurred.